Hello all, I am Jessica Franklin and the topic for today's video is meeting under the company law. So today we'll be discussing what is a meeting, the definitions, essentials of meeting, kinds of meeting, procedure for a valid meeting. The word meeting is not defined anywhere in the Companies Act. It can be simply defined as a gathering, assembling or coming together of two or more persons for discussion and transaction of some lawful purpose. A meeting can therefore be defined as a lawful association or assembly of two or more persons by previous notice for transacting some business. The meeting must be validly summoned and convened. Such gathering of the members of companies are known as company meetings. Now let us see a few definitions of meeting. In the case of Sharp versus Dwayne, the meeting is defined as an assembly of people for a lawful purpose or the coming together of at least two persons for any lawful purpose. According to P.K. Ghosh, any gathering, assembly, or coming together of two or more persons for the transaction of some lawful business of common concern is called meeting. According to K. Kishore, a concurrence or coming together of at least a quorum of members by previous notice or mutual agreement for transacting business for a common interest is meeting. Now, let us move on to the essentials or characteristics of a valid meeting. There are four essentials of a valid meeting. They are lawful assembly, two or more person, previous notice, and the fourth one, to transact a business. First, lawful assembly. The gathering must be for conducting a lawful business. An unlawful assembly shall not be a meeting in the eye of the law. The second essential is two or more persons. To constitute a valid meeting, there must be two or more persons. However, the Articles of Association may provide for a large number of persons to constitute a valid quorum. An exception to this essential is one-man meeting, wherein just a single person can make a valid meeting. There are 5 kinds of one-man meeting. The first one is meeting convened by the central government. When the central government calls for an annual general meeting under Section 167 of the Act, it may direct the one member of the company present in person or by proxy shall constitute the meeting. The second type is absence of quorum in an adjourned meeting. By quorum, we mean the minimum number of members who must be present at the meeting. If the quorum is not complete within half an hour of the prescribed time, the meeting will be adjourned to the same time, place, and date in the next week. If the adjourned meeting also the quorum does not complete, the members present shall be the quorum. Even if one member is present, may be allowed to decide and pass resolutions. The third type is meeting convened by Company Law Board, where the Company Law Board calls a meeting under Section 186 of the Act. It may direct that one member present in person or proxy shall be deemed to constitute a valid meeting. 4. Class meetings of shareholders. Where one person held all the shares of a particular class, that member alone was held to constitute a valid meeting of that class of shareholders. Now, the fifth one, meeting of one-man committee of board of directors. As per Rule 77 of Table A, the board of directors may delegate their work to a committee which may have only one member. When the meeting of such committee will be held, only one member will be present and he alone will constitute a valid meeting. Now moving on with the other essentials, the third one was previous notice. Previous notice is a condition precedent for valid meeting. A meeting which is purely accidental and not summoned after a due notice is not at all a valid meeting in the eye of the law. 4. To transact a business. The purpose of the meeting is to transact a business. If the meeting has no definite object or summoned without any predetermined objective, it is not a valid meeting. Some business should be transacted in the meeting, but no decision need to be arrived in such meetings. Now, let us move on to the kinds of company meetings. The company meetings are classified into 4. They are board meetings, meetings of shareholders, meetings of debenture holders, and meetings of creditors. The meetings of shareholders are further being divided into statutory meeting, annual general meeting, extraordinary general meeting, and class meeting. Now let us see what is board meeting. Board meeting are also called as meeting of directors. These are most important as well as the most frequently held meeting. In this meeting, all important matters relating to the company and its policies are discussed and decided upon. The Company Act therefore gives wide discretion to the director to frame rules and regulations regarding the holding and conducting of board meetings. Directors of most companies frame rules concerning how, where, and when the meeting shall be and how the meeting would be regulated. These rules are commonly known as standing orders. Board meetings need to be held at least once in every 3 months, and at least 4 such meetings shall be held in every year. The same has been dealt under Section 285 of the Act. There must be a proper quorum for every meeting. Quorum means the minimum number of persons who must be present at a meeting. The quorum for board meeting should be at least 2 directors or 1/3 of the total strength of board of directors, whichever is more. Board meetings are called for determining the policy of the company, to issue shares and debentures, to make calls on shares, to forfeit shares, to fix rate of dividend, etc. Now let us move on to the next kind of meeting, that is meetings of shareholders. Shareholders are the real owners of the company, but due to certain limitation, they cannot take part in the management of the company. They leave this to their representatives called the directors. For controlling the board of directors and their activities, shareholders meetings are held from time to time. The shareholders meeting are further classified into 4. They are statutory meeting, annual general meeting, extraordinary general meeting, and class meetings. Statutory meeting. This is the first meeting of the shareholders conducted after the commencement of the business of public company. Companies Act provide that every public company limited by shares or limited by guarantee and having a share capital should hold a meeting of shareholders within 6 months, but not earlier than 1 month from the date of commencement of business. It is conducted only once in the lifetime of the company. A private company or a public company having no share capital need not conduct a statutory meeting. The directors are required to send a notice of the meeting to all the members of the company at least 21 days before the date of meeting, stating it is the statutory meeting of the company. Annual General Meeting. Annual General Meeting is one of the most important meetings of the company. It is usually held once in a year. Annual General Meeting should be conducted by both private and public limited companies, whether limited by shares or by guarantee, having or not having a share capital. As the name suggests, the meeting is to be held annually to transact the ordinary business of the company. The object of holding this meeting is to review the progress and prospects of the company and elect its office bearers for the coming year. The first annual general meeting of the company is held within 18 months of its incorporation. After holding such meeting, it is not necessary to hold any other annual general meeting in the year of its incorporation and in the next year. The board of directors has to call annual general meeting, giving 21 days notice to all the members entitled to attend the same. However, such meeting may be called with shorter notice if it is agreed by all the members to vote in the meeting. It is called to adopt annual accounts, directors' report and auditors' report, declare dividend, appoint auditors and fix their remuneration, etc. Extraordinary General Meeting. Statutory meeting and annual general meeting are called the ordinary meetings of a company. All other meetings other than statutory meeting and annual general meeting are called the extraordinary general meetings. As the name suggests, these meetings are convened to deal with all the extraordinary matters which fall outside the usual business of the annual general meeting. Extraordinary general meetings are generally called for transacting some urgent or special business which cannot be postponed till the next annual general meeting. Every business transacted at these meetings is called special business. Extraordinary general meeting may be called by directors or be convened by the shareholders if the board of directors does not arrange for it despite the requisite. The second resolution passed at these meetings have to be filed with the register within 15 days. Class meeting. Class meetings are those meetings which are held by the shareholders of a particular class of shares. Example, the preference shares. Such meetings can be attended only by that class of shareholders. The articles define the procedure for calling such meeting. Class meetings are generally conducted when it is proposed to alter, vary, or affect the rights of a particular class of shareholders. Thus, for effecting such changes, it is necessary that a separate meeting of the shareholders is being held and the matter is to be approved at the meeting by special resolution. Now moving on, the third type of meeting is meeting of debenture holders. The debenture holder of a particular class conduct these meetings. They are generally conducted when the company wants to vary the terms of security or to modify their rights or to vary the rates of interest payable, etc. These meetings are called from time to time where the interests of debenture holders are involved. Rules and regulations regarding holding of the meetings of debenture holders are either entered in the trust deed or endorsed on the debenture bond. It relates to the notice of the meeting, appointment of the chairman, passing resolution, quorum of the meeting, and writing and signing of minutes. The fourth kind of meeting is meetings of creditors. Strictly speaking, these are not meetings of a company. They are held when the company proposes to make a scheme of arrangements with its creditor. Section 391 to 393 of the Companies Act not only give powers to the company to compromise with the creditor, but also lay down the procedure of doing so. Now, let us move on to the procedure for conducting a valid meeting. The first one, according to the Companies Act, it is essential that the meeting held needs to be in accordance with the Companies Act. Section 285 of the Act provides a framework for the settlement of list of contributories and application of assets. It is necessary to conduct a meeting at least in every 3 months, and at least 4 such meetings have to be held every year. In the case of Smith versus Paringa Mills, it was held that a meeting can be held in person or through video conferencing. Even a meeting held in the passageway outside the director's office is also valid. The second procedure, notice of the meeting. Before commencement of the meeting, notice should be given to every participant of the meeting. Section 286 of the Companies Act awards a penalty of ₹100 to those who fail to comply with the same. It is also essential that a notice is being served to all the participants within 21 days of the meeting. Failure to give the notice to the participants invalidates the meeting, and if any matter has been approved or disapproved in the meeting, such decisions are invalidated. 3. Agenda for the meeting. It is not mandatory to have an agenda for the meeting. The advantage of having an agenda for the meeting is that it enables the participants to come prepared to the meeting. Matters other than the agenda can also be discussed. 4. Quorum for the meeting. It is necessary to have a quorum to hold a meeting. Generally, the quorum for a meeting is 1/3 of the total number of directors or 2 directors, whichever is higher. If the quorum is not present, the meeting will be adjourned. 5. Conducting the meeting. The meeting has to be conducted in accordance with the principles provided under the Articles of Association for conducting a meeting. While conducting a meeting, votes are taken by raising hands, polls, etc. Debates have been conducted and resolutions have been passed. If the voting has taken into an equal proportion, then the chairman votes and his votes become the deciding vote. 6. Recording of the proceedings of the meeting. The happenings at the meeting needs to be recorded in a minute book, and the same shall be made within 30 days of conducting the meeting. This recording shall include the name of the participants, the date and the time of meeting, where the meeting is held, the purpose of holding the meeting, and so on. It should also include the issues discussed and also the resolutions which are taken. It is to be noted that the evidence for every issue discussed is also being recorded. It is also essential to provide the details of the next meeting. 7. Resolution of the meeting. Section 289 of the Act provides passing of resolution by circulars. Initially, they are circulated to the directors to obtain majority. The resolutions which are generally passed in meeting are regarding making calls for unpaid shares, issue of debentures, borrowing money, investment of funds, etc. Hope this video was interesting and informative. Thank you.